Welcome everyone, this is Tim Pullman and you're listening to the SEP Couch. This podcast is all about standard essential patents. We talk about patent strategies, FRAND licensing, patent pooling, and patent litigation. So let's dive into today's episode. She is the Secretary General of the Fair Standards Alliance. I'm very happy to have here today Evelina Kurgonaite. Hello and welcome.
Hi, Tim. Thanks very much for having me.
Yes, it's great to have you on my virtual SEP couch. And as always, I would like to hear a little bit more about you, your career, and of course, also in particular, how you came in touch with SEPs and FRAND and the whole topics that we all care about.
So I'm a competition lawyer by background. I spent, I guess, roughly half of my career to date practicing law at law firms. And my very first contacts with SEPs actually was after I changed from private practice to launch a European arm of a regulatory news service, PaRR Global. It was actually from the back office of the Financial Times Brussels Bureau back then. And it was also at that time that the European Commission opened antitrust investigations into abuses of dominant position by SEP holders that sought injunctions against potential licensees. And I was analyzing and reporting on those investigations, and I was totally intrigued by how important competition law was, and or like the role the competition law played in such an incredibly technical space, seemingly. And fast forward, and for the last 3 years, I have been with the Fair Standards Alliance, an industry association which advocates for fairer SEP licensing. And before I joined the FSA, I spent several years in-house at Samsung. And, I have been learning every day from my many members about any number of things related to standards and SEP licensing. And my competition background obviously helps because the commitment to license on fair, reasonable, and non-discriminatory terms, by its very nature, is a competition law safeguard designed to preempt anti-competitive behavior by owners of IPR, declared essential to standards that the rest of the industry gets locked into. So that's about me.
Very good. Great. Maybe also some background on the Fair Standards Alliance, just to understand that organization a bit better. Could you tell us a bit how many members there are, what kind of membership that is, how you can become a member, what kind of, type of companies you represent with it? What is the purpose, maybe?
So the very purpose of it, like as I already mentioned briefly, is we advocate for fairer licensing of standard essential patents. The organization is relatively large in the meantime. We have almost 50 organizations as members, and the membership is incredibly broad. It varies from very small companies, startups included, with just a few founders and small teams that help them out to grow their business, to really large ICT, automotive company groups, and they come from all over the world as well. So we have a lot of European automotive companies and their suppliers, but also international companies from different sectors. I think what I like to also mention when I talk about the FSA is that FSA represents companies from any level of the value chain. So really, we are looking at automotive companies that I mentioned, for example, at the end level of the value chain, those that produce the end product, the car, but also companies that operate all the way up the value chain at the producing chip, and then there are companies sort of anywhere in between as well. The organization is based in Brussels, but our advocacy stretches far beyond, because SEP policy issues are really picking up speed. As you will have appreciated, it's really sort of become, a lot of competition authorities are looking at these issues, but not only competition authorities, policymakers as well, and There is a growing number of litigation as well. And so it really keeps us busy, even though we are based in Brussels. I think what I also would like to mention is that a lot of our members also invest very significant resources into standardization. And a lot of them also hold SCPs. So it's not only sort of downstream innovators that innovate on the back of standards, but also many of our members do own SCPs as well. And all of our members, I would say, really the vast majority of our members hold other patents, multiple other patents to clarify. And so because our membership have invested a great deal into innovation themselves, our sort of look at these issues is really rather balanced, if you will, because we will never argue for positions that would impede incentives to innovate for our membership themselves, if you see what I'm trying to say.
Right. No, that makes a lot of sense. And I think what is very interesting, you are, working with a lot of companies on these specific issues and questions with regards to competition policy. So you represent a lot of, I would say, opinions or issues they have. Could you maybe tell us a little bit? Of course, I know you cannot elaborate on single companies' problems and issues, but more in general, what are the typical topics or the most pressing topics when we talk about FRAND? What are the issues that they have when it's about what is a FRAND license? What is typically in litigation, what people argue about? In your, if you think about it in the past years, maybe what has been the most pressing issues that you hear about?
I think it's a very difficult question, Tim. You have mentioned a number of challenges businesses face in relation to SCP licensing, and unfortunately, there are many more. And I find it hard to single one most pressing issue or like single one of them as the most pressing. It would also depend on whether you ask larger companies that may have the resources to defend themselves in court, for example, or whether you ask small companies that may have one in-house counsel for all legal matters. But if I must pick one issue that's most pressing, I would probably go for a cross-cutting issue. And that, to me, is the lack of legal certainty. Lack of legal certainty, in turn, translates into lack of business certainty, making it very hard for companies to plan, to estimate the risks, to allocate resources for research and development, and so on and so forth. So lack of legal certainty, I think.
Understood. Yeah, I think one reason is because we still have, not a clear understanding what FRAND is. There's not one definition, and with, all these different jurisdictions and policies and governments in place, I think that is, also a very complex space. Maybe understanding also a bit more some of your members. My understanding is often that or people keeps talking about the clash of cultures sometimes, because if you imagine an automotive OEM, they typically don't have large licensing teams or litigation teams because they work with suppliers. They implement technology that is based on standardized technology. And they're sometimes 2-3 steps away from, let's say, a connectivity box that implements 4G. So that is now a weird situation, I guess, that they are the ones that are, put on spot in litigation because, they have to negotiate the license. Can you maybe tell us or elaborate a bit how they manage that? Is that, how is that clash of culture still there, or has there been some adoption? Have these companies, are they now better prepared?
That's a very good question, Tim. And it sounds like there's at least a couple of aspects to your question that might be worth exploring here. One issue is the asymmetry of knowledge of standardized technology and patents that are claimed to be essential to a given standard. But also the example of the automotive industry, for example, that is often invoked, is interesting in itself because that industry is highly standardized and is also highly IPI intense, if one can put it that way. We're talking about hundreds of thousands of patents, right? That if you look at a vehicle, And in that respect, no wonder that the automotive sector has been in the lead of many consecutive years in the EU Innovation Scoreboard that compares R&D spending of various businesses. And the automotive industry is also an old industry. I think there's no way of arguing about that, which has long worked out the most effective ways to license patented, including standardized technology, and the most appropriate players in the value chain to obtain the necessary licenses. And a vehicle consists of thousands of components, and most of which are subject to standards because they have to be, and most of which are supplied by upstream component manufacturers. And often these are also single sourced from a supplier specializing in a particular product or a type of product. And over many years, vehicle manufacturers have consistently sourced those components free of third-party rights. And the industry has not considered it most efficient for car OEMs to seek licenses for standardized technology sourced from its upstream suppliers. And there are good reasons for that. It could actually be rather inefficient when a component manufacturer cannot get a license to sell their own designed products. Because when component manufacturers can get a license, it enables business models where they can clear a patent landscape for their own products and indemnify their OEMs because, as their question suggests them, component manufacturers are best placed to know their own designs, trade their own IP, or enter into cross licenses. It is not at all efficient when the licensor can sue, for example, 20 OEMs for buying an allegedly infringing third-party component. The component manufacturer then has to reimburse, negotiate, and potentially litigate multiple times to procure a series of licenses, one for each OEM. And this knowledge asymmetry is indeed another aspect that makes it inefficient to license standardized technologies at OEM level. And for at least a century, OEM manufacturers did not need to spend resources on developing extensive technological experience on every of these multiple standards their component suppliers were implementing. And imagine the absurdity of it for a second if they had to. It just doesn't make sense. Yet, certain SEP holders in the connectivity space in particular are now forcing OEMs to do that. And automotive OEMs, and particularly those that have operations in Germany, have really little choice in this respect. Now, faced with litigation or threat of litigation, automotive companies may still have the resources to try and develop such in-house knowledge. But imagine a group of graduates from the Berlin Institute of Technology, where I understand you are teaching. If these guys come together in a garage to create a cool hardware startup, I understand you lecture there, so perhaps they may have a good idea of SEP licensing, but still, an innovative IoT startup just wants to buy a small system on chip or similar, or box as you refer to it, and just plug it in. And they do not have the resources, nor should they, frankly, try to become experts in the underlying technology of every component they would source from a component manufacturer. So I don't know if that answers your question, but at least that was an attempt at it.
Right, no, very well understood. And I think efficiencies, it's a good topic, because I think that is one of the major issues that we see here. Because as you said, I mean, especially when one side has to get more knowledge on the technology because they are the ones that are approached by the SEP holders. But what I keep hearing a lot of other arguments about inefficiencies, and that the whole licensing negotiations, people even call it the FRAND dance, because it goes back and forth, and one party gives an offer, the other party has to reply to it. And there are a lot of delays. And of course, both sides of the table always argue that the other side is responsible. The SEP holders argue the net licensees, let me call them like that, they delay the process because they do that strategically. But then on the other hand, it is a very complex negotiation. And how do you find what is actually FRAND? And I keep hearing on the other side that the net licensees argue, well, if we get only half of the information, and if you're not transparent enough to give us enough claim charts or enough information on how your standardized technology is actually implemented in our products, how can we really, react to that? What do you see here? I mean, what is your view on these inefficiencies? Do you see a lot of examples where also there's just not enough information to make an appropriate response to an offer, or what is your experience here?
It sounds as there is many more than one question within this one question, Tim. I think maybe I would like to talk a little bit about the practice of delaying on the net licensee side, and I think you didn't mention holdout, but that's something that we've been hearing from some stakeholders in this debate, and a holdout is often referred to in this context as a delaying tactic, if you will, by potential licensees. And I just want to talk to it a little bit. As a competition lawyer, I can't help myself there. It has emerged as an antithesis to hold up, and hold up is acknowledged by competition authorities as an antitrust concern, because it can be, and there are reasons why it should be. But whereas I fail to really understand a holdout is a competition issue. The US Federal Trade Commissioner Rebecca Slaughter gave a very insightful speech at the end of 2021. And I thought she did an excellent job with explaining very clearly why holdout is not a competition problem. And that's because she explains it simply does not pose the same concerns from a competition standpoint as holdout, which, when pursued by a dominant SCP holder, has the potential to exclude firms from implementing a standard. Whereas unilateral holdout, because there is no market power, does not involve the abuse of market power to impede consumer choice that holdup does, and therefore does not trigger antitrust concerns in the same way. Now, moving to the question on the sort of contention side of negotiations, my impression is that most contention is really around only a couple of standards out there, and it is particularly contentious when it comes to cellular connectivity standards. And what SCP holders claim is a holdout, in my opinion, is a direct result of their own doing, so to say, by targeting players in the value chain who legitimately expect that such licenses would have been taken by their suppliers. It's really, sort of a starting point where the contention starts as well. And it is in the cellular connectivity space that certain SCP holders started refusing licenses to upstream component manufacturers, unlike it was done in the past. You probably will have seen that case law in the US, namely the FTC versus Qualcomm. I'm not really going to talk so much about the law issues in that ruling, but what I felt was interesting is that through US discovery, there was a lot of internal documents and sort of executive statements that came to the fore as a result. The case has a lot of evidence that shows that previously SCP licenses were made available for semiconductor manufacturers, and internal documents of Qualcomm revealed that the licensing practices changed because it was humongously more lucrative to license end product manufacturers. And evidence quoted in that case law also reveals then that, and I quote unquote, Nokia and Ericsson then followed suit. And I think so one can presume that part of a contention in the negotiations stem from that sort of humongously more lucrative starting point from SCP holders. The other is that end product manufacturers typically buy some sort of a box, as we spoke earlier, smaller or larger, more or less sophisticated, depending on the needs in a given case, to add the connectivity functionality to that end product. And they're not really used to negotiating licenses on these things. And then you also mentioned the asymmetry of information, which I think also plays a role here. And I think that asymmetry is magnified significantly when licensees are smaller players and have limited experience and expertise in negotiating SCP licenses. And what we know from our members, or also from our members' customers' cases sometimes that have been approached by SCP licensors, is that licensees typically do not possess basic information that SCP holders have. For example, and I'm really talking basics, right? Like whether a license is needed from a technical perspective, whether the terms offered comply with SCP holders' commitment to license and FRAND terms. And it includes, among other things, information about the size and strength of the patent portfolio, the number of other licensees for the same standard, like just the basic information on sort of a patent landscape, and any other terms and conditions that those other licenses may have entailed.
Very interesting to elaborate on that. One other thing that I keep hearing, but actually also for both sides of the table, is sometimes the difficulty with extended NDAs. From licensees, I keep hearing that, it is a lot of investigation needed when someone approaches you. You have to check the patents that are offered. Are they really essential? And again, if you're not an expert, if you don't have that in-house, you employ a lot of outside counsel. And we all know these experts are very expensive. And the big issue is that often one portfolio gets licensed across many licensees, and all of them individually have to do investigation on, let's say, patent quality, to keep that one example. Because of these extensive NDAs, there's no sharing of information, or there's nothing, transparent that I say, this is the licensor, they go out with this patent portfolio that has been, challenged and understood of that kind of quality or not. That of course sounds, I'm an economist, sounds very inefficient. If let's say 10 licensees have to evaluate the same portfolio all over again, it's repeated work, and it doesn't make sense, to do that all over again. Are there any other examples, or, what's your opinion on NDAs in general? How can we get maybe transparency that is beneficial for both sides of the table? Is there any ideas there?
Yeah, no, I agree that it really is not very efficient. But the reality is that rather than openly sharing some basic information with potential licensees, some patent holders routinely impose excessive secrecy obligations to obscure information about their portfolio strength and licensing practices. And what they do, they require potential licensees to enter into very restrictive non-disclosure agreements. And when I say very restrictive, it can have provisions such as restrictions for potential licensee to discuss this sort of, potential licensing with their suppliers, for example. And they make, I would argue, rather basic information on for FRAND negotiation and licensing contingent on signing that NDA. And at the same time, SCP holders often represent to potential licensees that other companies have accepted those terms. And that, they were like, look, others have signed, like, you just have to sign here. And the reality is that, again, for especially less sort of experienced, typically smaller players, potential licensees have no way of verifying if that's true, or and precisely because the NDA, as you mentioned yourself, because the NDA has been imposed by SCP holders on other licensees. And, I think just maybe to caveat this a little bit, while the parties may voluntarily agree to appropriate confidentiality limitations in an NDA, and we're not necessarily arguing that NDA is always inappropriate and that nothing should be confidential, but because of this sort of inherent information asymmetries in SCP licensing, any such NDAs must not be the product of coercion, or must be a condition for a FRAND license negotiation. Because that would be entirely against sort of the spirit of FRAND and good faith negotiations. And if SCP holders are allowed to effectively force potential licensees to accept secrecy as a condition to obtain a license on FRAND terms. And so from the FSA's perspective, things could be a lot more efficient if some basic information was not made contingent on an NDA. And by basic information, I mean things like listing of patents that are being asserted, identification of sections of a standard where each alleged SEP is practiced, claim charts, the basis and methodology upon which the offer was calculated, historical rate and licensing information, and details of litigation, existing challenges to the validity of any of the patents in any jurisdiction, and information regarding prior licenses, settlement agreements, or covenants not to sue with third parties. Imagine how the world would look very different if this kind of information was available to potential licensee every time. Then indeed, I think we could really expect the sort of the dance that you were talking about earlier would be much smoother and considerably less there would be less obstacles, less stumbles, and it could really be a nice dance or nicer dance. Because a lot of time really goes on SP licensees trying to figure out information like such.
Right. But one way to overcome inefficiencies, at least from an economist view, in theory at least, would be a great solution is if we had more patent pools. One example we have, I think also many of your members have been approached by a pool called Avanci. They set up a specific pool program tailored to the automotive industry. How does, and they are, for example, they just said they're gonna, release soon a program for 5G. Do you think patent pools in general are the solution or can be a solution? And, what are pros and cons of patent pools? And, any opinion on Avanci in particular?
Yeah, and there's quite a few questions in there. I think starting with a more general one, which is whether patent pools can be a solution. Yes. And they have proven to be a solution, and there are several patent pools that many of our members are participating in, and they work very well. I think so long as they are FRAND, there's no issue with that. But when patent pools are not FRAND, or when they actually openly claim they don't abide by FRAND, I'll come back to that maybe in a moment. And what do we mean by FRAND? There again, I think like the basic transparency is very, very important, because if you have a patent pool that doesn't disclose what kind of patents are at stake, that, for example, there's no transparency at all as to how they have arrived at what sort of methodology they applied, how they arrived at a certain number that they claim is the appropriate royalty rate, how that number doesn't correlate at all with portfolios perhaps aging, patents expiring, and things like that. So basic transparency is extremely important, and transparency along the lines that I have outlined earlier, right? Like in basic information about the SEP portfolio that we're talking about. Now, turning to Avanci in particular, I think I personally, again, as a competition lawyer, was very disturbed by this information that I've learned that an Avanci legal counsel in a courtroom told the judge in the US that actually Avanci is not subject to FRAND, that there's no reason why they should abide by FRAND. I find that disturbing on many levels, because if this was true and if this was allowed to go forward, not only for Avanci, but really for any patent pool in the future, then this is like just your perfect way for SEP holders to, just make that commitment when they contribute their technology to a standard, and then circumvent it. You just outsource the work to a patent pool, because the patent pool then does not abide by FRAND, and there you go. I think, again, and not only I, but also regulators should be very concerned about this. There's really something that I don't think makes this particular patent pool a very good solution for the industry.
And on what ground do you think can it even be argued that a pool of SEPs should not be subject to FRAND? Is there any legal foundations of that, or?
I wouldn't want to speculate because I don't know why the why a patent pool would make this kind of assertion. We have case law where an advanced legal counsel appeared before court and made that assertion.
Interesting. You talked about regulation, and there are rules out there, laws out there, unfortunately complex because we have different jurisdictions. But I think one thing that I at least think is something that has improved, regulators have starting to ask the industry, public consultations is here the key word. And we've seen many public consultations this year. The US, I think, started, Canada, UK, and now I think a few weeks ago, the European Commission. Public consultations where anyone can submit something. So in your opinion, or representing the Fair Standards Alliance, if you had a wish, what could regulators, or what should regulators really change with regards to FRAND and SEP licensing?
It's difficult to answer that question as a sort of a blanket response because the various consultations that you just referred in different parts of the world will focus on different aspects of it. I think from my point of view, and that's probably more my personal opinion than sort of FSC's position, but I don't know if legislation is really necessary here. I think more competition enforcement would be good because there is already, at least in Europe, there is already a case law that clarifies a great deal on, for example, on the use of injunctions. There is also EU law that has very clear language on license availability. If those were simply enforced a bit more rigidly, things would be, I think, very different today. And by legal certainty that I mentioned, or lack of legal certainty that I mentioned earlier, I really meant that, the sort of I think the lack of legal certainty emerged from SEP holders deviating from that case law, sort of pursuing licensing practices unlike they have been doing in the past. For example, the case law that I mentioned earlier in FTC versus Qualcomm, it actually, again, like evidence, and I'm not talking about law, but really evidence quoted in that judgment shows that it was against the advice of their own legal counsel that they decided to discontinue licensing semiconductor manufacturers. So it's really sort of, despite the existence of the law and despite the them understanding the law correctly, they have just decided, like it's humongously more lucrative to do things otherwise, and we shall try. So I don't know if more regulation would necessarily change that. Perhaps more enforcement would. Now, if regulatory authorities were to go ahead with legislation, I think then it would be very important that then they sort of, again, in the spirit of continuity of legal certainty, whatever that legislation or guidance that will come out of these consultations would actually be in the spirit of its previous case law. And again, if I were to talk about the European Commission, I think it would be very important that legislation that will come out of, I guess, the two ongoing consultations right now, one on the initiative that comes from DG GROW and the other one from DG Comp, which is on the horizontal guidelines. So I think particularly the one that would come out from the initiative that DG GROW has started, I think it would be very important that any such legislative proposal sort of maintains at least the basic EU law, the case law that has previously been there. I think if we wanted, where we would want to have a bit more clarity is indeed then reinforcing that the law, the sort of a case law that has previously been there, and clarifying indeed in very unambiguous terms that licenses should not be limited to any one level in the value chain, and that use of injunctions should be very limited when it comes to SCP licensing. And obviously, there is also ample room for improving transparency in the SCP licensing space. So I would say those three would be something where I think would be worthwhile spending some ink on guidance at least.
Evelina, this has been great, so enlightening, lots of good discussion here. My very last question for everyone who is on my virtual SCP couch is, what do you hope our audience will keep remembering from this today from you? What is your elevator pitch here?
Licensing practices as they have deviated from law as we knew it. This has created a lot of legal uncertainty that will, that continues obstructing businesses, small and large. There's a growing number of litigation, and that's really just nothing very good for Europe. And I think that would improve tremendously if it was sort of somehow reinforced that use of injunctions should be very limited, because so long as injunctions are readily available, as though SCP context is not very special, we will continue seeing terms that are potentially non-FRAND, and we will continue seeing slowdown of IoT uptake, and I think issues will persist, and issues for small companies will be particularly painful.
Great, well understood. This was Evelina Kurgonaite from the Fair Standards Alliance. So good to having you here on my couch. Thank you so much for coming.
Thanks, Tim. It was my pleasure.